Have you ever stopped to think about what would happen to your hard-earned assets when you're no longer here? Planning for the future is crucial. Wills and trusts help protect your assets and your loved ones, but which one suits your needs best? Let me break it down and share why I lean towards one more than the other. Now, before I jump in, do not consider this legal advice. Please take any information I give you and use to research what your options are, or seek out the help of a licensed attorney that knows the laws in the jurisdiction that you reside in. To start off with, a will is a document where you designate where you'd like for your assets to go. A will requires you to use the court system, the probate court, in order to distribute your assets. A will requires a judge approve the distribution of your assets. It's also a public document, so when you pass and the court is petitioned to distribute the assets, your creditors will know that you have assets, and they will have the legal right to come after those assets. And they will know again because that document is public. The process is lengthy and can be anywhere from 12 to 18 months. You will not be able to speed this process up. This gives the creditors an opportunity to come forth and prove that the person whose assets are being distributed owes them money. Like a will, a trust passed on assets to those that you have identified. A trust will avoid the court process. So with a trust, once you pay the fee for the trust, there should not be any significant fees involved to transfer your assets to the person you have designated. It avoids the court process completely. The process for a trust is less expensive, and it is automatic that the people you have designated will get your assets. A trust is definitely recommended if you have real property that you want to go to a designated person after you pass. For both a will and a trust, you do not need to add assets, bank accounts, retirement accounts, insurance policies. You do not need to add those things to a will or a trust. You just need to make sure your beneficiaries are updated regularly. My plan to keep my beneficiaries updated on my documents is to set my phone as a reminder to make sure my information on bank accounts, on retirement plans, on insurance policies are updated. Lucky for me, I only have that one child, so I don't really need to change mine that frequently. But you want to make sure that you have updated beneficiaries on those documents. I'll share one experience. I recently had a former coworker who passed. His wife passed several years ago. He did not change his beneficiaries from the wife, and now his family will likely have to go through a court process in order to get his retirement, in order to get his 401k plan, any insurance policies that are out there. They will have to go through the court system to I want to say fight that out in court, but they will have to go through the court in order to get his assets distributed. He owned a home and everything, and even after 4 years, he had not updated his beneficiary. Now, the trust is the easier, probably more expensive on the front end. Here in California, you can probably get a trust from anywhere from $900 to $1,500, but again, it saves your family the cost of going to court and having the assets distributed. And along the lines of talking about assets, you with the bank, the documents are usually called they call them POD, payable on death, and TOD, as in Tom, TOD, transfer upon death. Those are the forms you're filling out so that when you're no longer here, the person you designate can get the money from your bank accounts. There are certain accounts you do not want to add to your trust. Those would be like an IRA account and your 401ks. Don't add those because they have where you can designate the beneficiary to receive those funds. Now, my chosen route for distribution of my assets is a living trust. And as I stated earlier, the living trust avoid the court process. If your family has to go to court over your assets, you only have a will or die without a will. Even if you die without a will, you will still have to go through the probate process. But you don't get to designate who gets your assets. I mean, there's a natural order: your spouse, your kids, your parents, your siblings. But if you don't have a will or a trust, you don't get a say or get to designate where that property is going. The reason I'm choosing the trust over a will is because it saves a lot of money. Here in California, it's nothing to pay $750,000 for a house, or for the value of a house to be $750,000. That might not be what you paid for it, but the value may be $750,000. And I did the calculations on that, and in order to pay the fees for the probate process, again, you have court fees, you have attorney fees. Those fees, and plus the person who is designated to distribute the assets in the trust, the executor, gets funds as well. On a property valued at $750,000, you would pay fees of $37,000, $36,000 or $37,000. That is a lot of money, and not a lot of people have that kind of money sitting in the bank. So think about it. You want to leave your property to your kids, and if they don't have that kind of money, they're going to be forced to sell the property. Some of you are okay with that, but some of you want the kids to hold on to the property. So you are better suited if you go ahead and set up the living trust and spare them the court process and the fees. Another thing about the living trust, yes, you place your assets in that trust, but you still have complete control over what you do. It is still your property, and your family cannot do anything with it until you are no longer here. One thing I will advise here is these insurance companies, homeowners insurance, it's being so funny right now that if you get a trust and you put your property in the trust, don't call, write, email. You want something where you'll have documentation that you contacted them, and you want to add the trust as a payee in the event something happens. Because if you have a catastrophic incident and that property is in the trust, a lot of policies will not pay you because that property is in the trust. So you want to make sure when you switch it over into your trust, when the trust is holding that property, that you add on to your insurance that the trust be a payee, so that if a catastrophic event happens, the insurance cannot wiggle their way out of taking care of and making you whole with that property. You want to place any real property you have, any stock portfolios you have, or any brokerage accounts into the account, but not your retirement. Most people go with a revocable trust. That means you can change it anytime you want. You have no restrictions on how you change it. There is something called an irrevocable trust, but I won't go into that because that is a lot more restrictive, and it has some limitations once you make it. So you need to research that and see if that is an option for you. But most people go with the revocable trust because you maintain control and can change it as you need to. There is another way for you to transfer your property if you own it with someone else, as long as title is joint tenants. Joint tenants have the right of survivorship, and if something happens to one person, the property is automatically transferred to the other person. You do not have to go through probate if you have title as joint tenants. Another option that I'll discuss briefly is called a transfer on death deed. This is a document that you sign, that you have notarized, where you can designate the person you want your property to go to. After you are no longer here, that person can take your death certificate, that document that was signed in front of a notary, register it with the county recorder, and they will transfer the deed to that person. This will also help you avoid probate court. You don't need a living trust to do it. I would still suggest you do it, but you don't need a trust. There is no court process in the transfer on death deed. The limitation I know with the transfer on death deed is that you must do it within 9 months. After 9 months of the person passing, that deed is no longer valid. And so if it's not filed in time, you will find yourself in probate court. So for a recap, a will is costly, time-consuming, and must be monitored through the court. A trust, you put your assets in, they're able to be distributed right away. You avoid probate court. If you have joint tenants, you bought a house with somebody, that house will automatically transfer to the other person upon death, and the transfer on death deed will allow you to transfer your property to someone after you're no longer here, as long as they transfer that property within 9 months. You must have that document signed by a notary. Thanks for taking the time to learn about wills and trusts. Making the right choice can secure your legacy and protect your loved ones. Until next time, take care and plan wisely.